Thank you very much. Thank you, Ms. Niekerk. Honourable members, officials, support staff, I want to say thank you very much for joining us this morning for this meeting of the Standing Committee on Agriculture, Environmental Affairs and Development Planning. Today is Tuesday, the 25th of August, 2020, and it has just gone 9 o'clock. And thank you very much. Our agenda for the day is to discuss the submissions received in relation to the National Forests Amendment Bill, the National Environmental Management Laws Amendment Bill, and then we were to also consider the National Department of Environment, Forestry and Fisheries response to these public comment. Unfortunately, I've been informed, and Ms. Nika can perhaps just confirm, that response has not been forthcoming.
That is correct, Chairperson.
Thank you. So, honourable members, as you will recall, some 2 weeks ago, we then received a request from the National Department that they would like a postponement, and they actually proposed that it be postponed until last Friday, which was the deadline they have set themselves. And we then had to cancel our meeting last week because we felt that obviously we would love to have their input before we start applying our mind. So it does put us in a disadvantaged position. On the other hand, we are dealing with bills, and particularly the NEMLA bill with its 85 clauses is going to take, and it's expected to take quite a considerable time for us to work through it. And I would like to propose that, despite the National Department's comment not having not received their comment, that we start going through the bill clause by clause. We can always come back should some of their comments warrant that, but that we don't postpone, otherwise we are going to run into time constraints, and I would hate for the Western Cape not to be able to submit their negotiating mandate to our representative there. So members, I put it to you that we do have some challenges, but I do believe it to be in the best interests of this committee to indeed continue with our deliberations. And I think dealing with it clause by clause will also help ourselves get a better understanding of the bills in front of us. I hope that is acceptable to the members. Silence on this platform is normally taken as support. Can I then just also say thank you to the members who are here, and perhaps they can just quickly introduce themselves. I have received an apology, and I don't know if our procedural officer also received a copy of that, from Honourable Deirdre Baartman, who cannot join us here today. And can I just quickly give over to you, Ms. Niekerk? Did you receive such an apology?
Yes, Chairperson. I've received an apology from Member Baartman as well as from Member Brett Herron.
Thank you. The apologies are noted. And Honourable Baartman indicated that Honourable Derek America will be standing in for her. So welcome, Honourable America. And I do know it's not easy to deal with legislation at such a short notice, but we really appreciate it, and we're looking forward to your input as well. Perhaps for the record, you could just state your name on the recording as well.
Thank you, Chairperson. My name is Derek America. I'm an alternate standing in for Honourable Deirdre Baartman. Thank you.
Thank you, and you're most welcome. And Honourable Maseko, now that we've officially opened the meeting, perhaps you could also just confirm your presence.
Good morning, everyone, and good morning, Chair. My name is Matlodi Maseko, and I'm a member to the Standing Committee. Thank you very much.
Good. Thank you. And then from the Department of the Western Cape, Department of Environmental Affairs and Development Planning, perhaps the staff there would just like to introduce themselves as well.
Good morning, members.
Mohammed.
Good morning, Chair. This is Ayub Mohammed. I'm the Chief Director, Environmental Governance from the Department of Environmental Affairs and Development Planning. In the meeting, we've also got Mr. Paul Hardcastle, who's the Director for Policy Coordination, Ms. Kaylin Mahota, who works in his section, Special Environmental Officer, and Michelle Mellum is from the Department of the Premier Legal Services. So that's the officials who are present in the meeting. Thank you.
Thank you very much. And then, may I just, I see Mr. Marsdorp has just joined us as well. Good morning and welcome, Advocate Marsdorp.
Thank you, Chair.
I do not happen to see Advocate Andre Leroux.
Chairperson, he will be with us shortly. He's just trying to connect.
Good. Thank you, Ms. Nika. Honourable members, as I've indicated earlier, the National Forest Amendment Bill seemed to be much shorter and much simpler in the sense that it only addresses one main bill or act, and that is the National Forests Act, while the National Environmental Management Laws Amendment Bill speaks to 7 pieces of legislation, some of which have gone through various previous amendments as well. So if it's fine with you, I would like to propose that we start with the National Forest Amendment Bill. I think it will also then free up Advocate Marsdorp once we have dealt with that one, so that he doesn't have to stay online for the long, lengthy discussion regarding the NEMLA. Can I therefore then ask, welcome, honourable members, our delegate in the NCOP has requested me that if we want to consider the different clauses in these bills, that we indicate our support for a clause, that indicate any amendments, and that the amendments should be framed in such a way that I almost want to say it should, the NCOP should be able to adopt that as a word per word or verbatim as an amendment to the piece of legislation, so that we don't just express, questions and raise issues, but that the final negotiating mandate that we give to her should be in a form where she could say, Chair, the Western Cape proposed the following amendment, and that she would then be able to carry that into the meeting on that side. And that is why I intend going clause by clause on our side through the bill. And we don't need to finalize our negotiating mandate today. We still have about 2 meetings after this that we would be able to fit in. But that, and particularly with the National Department not coming back to us as promised, we may have to come back. But I think by then we would only we would save time by only going to the, let's call it the problematic or the clauses that requires further consideration. Good. So thank you, honourable members. I do hope that you have in front of you or on your computers, obviously the bill that is in front of the committee, that you also have on your computers or in front of you the Forest Act, and that we and that you therefore would be able to go through this. I hope I'm correct. If I'm going to use the following, can I call it wording? If I refer to a clause, I refer to what is stated in the bill, which is numbered 1, 2, 3, 4, 5. If I refer to a section, perhaps a paragraph, then I would be referring to the main act. So the clause for me is what is in the bill, and the paragraph or section, I will be referring to the act of, in this case, 84 of 1998. And I do hope that that will help us to be able to be with one another, because I think we have this disadvantage that we're not sitting around a table and we can't show each other on which page we are currently. And I do hope that will assist us. Any other proposals apart from that, or can we then start with the bill on page 1? Again, I take silence as confirmation that we are, though not literally, but by figure of speech on the same page. Okay, good. Good. Thank you. And in terms of the bill, one, we find a number of definitions. I want to put it to you that there's no problem with the definitions and that we therefore support that clause. The second clause, there have been some public comment on that as well. The first one is in paragraph then 2A, the national government as the public trustee of the nation's forestry resources. Apologies, honorable members, it is our refuse removal day and the neighborhoods, the dogs are keeping us all safe and mine is not innocent either. So there have been questions about the wording trustee, and the trustee may be handing over, I almost want to say, a lot of ownership to the national government, and that there's a lot of distrust in terms of national government's role, and that trustee is also the word used in terms of the traditional affairs, where the chiefs are the trustees of that land, and that in that respect, we don't want, or the public has commented, they don't want a similar situation to be in terms of our forests. So I would like Advocate Marstorp's input regarding the term trustee versus custodian or something similar, or for the word trustee to be limited in some respect, the need for that. And then the Friends of the Stellenbosch Mountain in their comments said they believe this paragraph should be scrapped. So that's the first issue in that paragraph. And the second issue, which some people saw a potential problem, is where the words are used: protected, conserved, regulated, that also sounds controlled. But then there are other words like developed, utilized, and managed, where some people have seen a potential conflict. Those were the public comments. And then just from my side, I've been wondering if it wouldn't be good if we, from the Western Cape side, add the word there in line 20 for the long-term benefit of all persons. And the reason for that is, forests are prone to things like fires. You could have infections of all kinds, which sometimes in the short term require steps that may seem on face value to be taking a step backwards, but it's still in the long-term benefit or interest of the environment and therefore persons. So those were the issues raised. Can I first just give the members any comments from you before I put it to Advocate Marstorp? And Advocate Marstorp, if you say, well, park that one with me, come back to you next week on the whole issue of what does trusteeship, is it the best word that we can come up with? Then you indicate as such, and I will make a note, and obviously next week we will come back to that one. I see Honorable America's microphone is off. You want to speak?
Chair, not as yet. Thank you. I will make a comment later. Thank you.
Thank you. Silence. Then over to Advocate Marstorp.
Thank you, Chair. If I understand the Chair correctly, Chair is inquiring as to the use of the word trusteeship as it is used in clause 2 as a new insertion, clause 2A. as opposed to a custodian. Is that my understanding of the Chair's question?
Correct. Advocate Marstorp, I'm just struggling to hear you. It seems to me as if you may have some bandwidth questions. And I omitted to say, obviously, from a provincial point of view, we would like as much powers appropriate and where a province is in a position to be able to do it, to not relinquish, trusteeship or particularly control to the national government, in the sense that, some of the comment also suggested that this trusteeship could and should actually rest with the provinces. But here,
well, that's not for me to comment on, Chair. The interplay, if you like, between province and national, I look at the bill for its integrity as it stands, whether it satisfies constitutional requirements and principles. If the committee, of course, feels that it needs to make proposals or provide a mandate which speaks to its preference for a more provincial interest or a greater provincial hold, then that is certainly the call of the committee. As it stands, and I'm still trying to just get to the bottom of the context of Chair's question pertaining to trusteeship and custodian, but let me just volunteer the following. In the context as it is with me now, those two terms seem to be interchangeable. The primary, if you like, mandate for a trustee is to act in the interest of and on behalf of something and or someone or group of persons. From what the text of the inserted clause 2 capital A seems to suggest, is to simply state it provides a statement of purpose to suggest that the national government acts in the interest of and on behalf of the nation in respect of its forestry resources. And the minister is simply a vicarious representative, is simply the default representative to ensure certain objectives, whether it is protection, conservation, development, regulation, or such noble, on the face of it, noble objectives. Similarly, if one should even insert a custodian as a reference, then in this context and textually, it would suggest very much the same, that a custodian is someone who acts in the interest of or on behalf of another person or another thing or group of persons. So on Chair's question, there does not seem on the face of it to be a dramatic or principled difference between the two concepts. In fact, they are very much, in this context, interchangeable. That's it for now from me, Chair.
thank you very much. Advocate Marstorp, I take it that you will also make a note on your side, perhaps just go and test it against the Constitution, and you now know that this is an aspect that has been raised. And for now, we accept your view that this is that you're happy or that you're comfortable with that term being used. But should anything else arise from a greater exposure or benefit to go? Okay. And then, honourable members, would you go along if we include the word for the long-term benefit of all persons? Seems again.
Agree, Chair.
Good. Thank you. And Mr. Kerk will minute that as well. And that we then, in terms of developed and utilized, I can just say in my frame of mind, that utilized of a natural forest would include, for example, for recreational purposes without doing undue damage to the environment. We see these treetop tours. We see hiking trails being constructed within, and for me that is part of the sustainable utilization of such forests. I see Advocate Mastrop, your microphone is coming on and off. Would you like to comment on that or?
No, Chair, I need to switch it off. It's fine. Sorry about that.
Okay, good. Thank you. Thank you, members. So we then, that's clause 2. Clause 3 seem to not have raised any major issues. In clause 4, so we're now on page 4, they speak to a person may not conduct any activity in a protected area which is inconsistent with the conservation, the recreation, or any other management objectives of that area, except under a license issued by the minister in exceptional circumstances that may be determined by the minister. And the comment was that exceptional circumstances is too vague. Any input from any official, from any member, from our legal advisor, in terms of that comment that exceptional circumstances, that would be a term that would better describe the circumstances under which exceptions would be allowed. Any proposals? Going? Gone? We then remain with exceptional. And we support clause 4 as well. Clause 5. No major input on clause 5, so that is also supported. Clause 6. Quite frankly, just a comment from my side, there are a number of these pieces of legislation, the minister must give notice to the public, and in general, it's still obviously sometimes the Gazette, newspapers, and radio stations. The legislation is quiet on electronic media and social media, etc. But quite frankly, I also couldn't come up with what social media, because it's such a dynamic environment. I wouldn't like to use certain platforms' names. I did think that perhaps one would be able to just add that on the internet, or on the department's website or something like that. That I don't think that would be uncalled for or subject to such quick changes. But it's just a comment from my side. If the department is happy to continue paying for adverts on radio and in the print media, although print media seem to be on the decline. Same with section clause 7. I put it to you that it seems to be one which is generally accepted. And clause 8. Was also generally accepted by the public and by the department. And you must please correct me if any one of you. Then in clause 9, section 23 of the Principal Act is hereby amended by the addition of the following subsection. No person may engage in any prospecting or mining activity in a state forest except in terms of an existing lease agreement or any other valid contract, which I think one can understand. And then it says, or applicable legislation. And some of the comment was that applicable legislation is also a bit too wide. Quite frankly, I put it to you, honorable members, if other legislation does allow such activities, then I don't think that is too wide. Either legislation apply to or it doesn't. So I want to put it to you that we skip that one and accept it as it is. The same then for clauses 10, 11, 12, 13, 14. Those are all generally accepted. clause 15, on clause 15, which deals with the wonderful aspect of setting up an appeals body for to test decisions of the minister against or officials that may make certain decisions. And so it sets up an appeal body and sets down some of the rules for the appeal body. So I want to put it to you that in general, I think although there's always a cost involved, that we support the setting up of an appeal body. There was the one, and it was also generally supported. There was the one issue raised, and that is the issue of the timeframes for the appeal committee to consider, applications or appeals. And perhaps we could leave that with Advocate Marstorp as well. And I want to put it in the following way, Advocate Marstorp, because I presume you would like clarity on what is expected of you. The first one is, should time frames determining the functioning of the appeals committee be included in the Act, or should it be by way of regulations? And are there provision for such regulations? So that's the first question. Should time frames be in the Act and then secondly, if we do believe that time frames are a good thing, and I would like to put it to the committee that we from the Western Cape should consider referring to time frames with that, so that appeals be dealt with, within a certain time limit. What would such appeal periods be, and how can we describe it in clear legal language so that we take both those people that appeal and those affected by the appeal, and to bring clarity regarding the position of the various parties in such an instance. Okay. And that then over to the members, to the officials, to Advocate Marstorp. Mr. Mohammed?
If I may comment.
Recognize you.
Okay, thank you.
Please do.
Our experience has been that it is better, time frame should be in the regulations. If it's in the Act, it will have to go through an entire legal reform parliamentary process to amend. We are governed by PAJA in this regard, so it's always a reasonable time frame, for example, that is imposed. Normally, like we must make in current EIA regulations, for example, that currently is the appeal. The appeal time frames is governed in the regulations, and the minister has 90 days within which to make an appeal. We might want to also consider that we can establish the appeal committee in terms of the Act, but the further detail should rather be dealt with in regulations. And it's easier to amend regulations than to amend the Act. So the enabling provisions and this new appeal committee is accepted, but they should consider rather doing the detailed processing can go into the regulations as well as time frames. So that would be our proposal, and that's currently it works best in our experience, that regulations can deal with the details of the appeal process. Thank you.
Thank you. I see Honourable America.
Yeah, Chair. Mr. Mohammed preempted what I was going to say. I also agree that timeframes are best specified in regulations for the very reason that's stated. But having said that, I would be of the opinion that we should set outer timeframes and not specific timeframes. That gives us a fair amount of flexibility. Thank you, Chair.
Good. Thank you. So it seems to me the issue of the timeframes in principle is supported, but not for us to include that into the Act. And therefore, I think what it is then just to make sure is that the Act allows for regulations which must include timeframes to be drafted. So, Advocate Master, if we could park that with you, is there a requirement in the Act, in the bill, for such regulations to be drafted, including timeframes as part of those regulations?
Good work, Chair. Maybe just for my understanding, Chair, if I may.
I think we lost the chairperson. You may say.
Well, I would like for us to maybe find the
Sorry,
chairperson.
my apologies. My apologies. I've said go ahead, and I can't understand why you're not following. But I was on mute, still trying to manage the background noise. Advocate Master, please go ahead.
Yeah, no, I was just trying to get some clarity, but I think I sorted it out for myself in your muted absence. I think, Chair, that there seems to be agreement that specificities like timeframes, etc., in relation to process, whether it's appeal or such processes, would ideally not be suited for an Act, and the Act should simply really just provide for an enabling space for appeals to be happening. So if I accept that as a premise, that we are more comfortable to have time frames and such matters to be provided for in regulations, as we know, regulations are more sort of fluid and flexible sub-legislation, if I could call it that, and more easily changeable as opposed to exhausting a full-on legislative process. If I accept that as a premise, is the expectation and is the request from Chair to me that an amendment or a proposed amendment should really just suggest or provide for regulations to provide for timeframes? Is that effectively the verbatim or the reach of the verbatim that is expected to be drafted?
Yes, thank you. Please go and check whether it does not only allow, but whether it requires regulations to be drafted, determining the appeals committee's work. And then also it must speak to the fact that the regulations must include timeframes for the committee to also deal with such appeals. Please go and check that for us. Okay, thank you. Then section 16, there seems to be general support for the very, very steep increase in fines for people being guilty of transgressing the National Forest Act. Then 17 was generally supported, and the department was, please correct me if I'm wrong, the same with 18, 19, 20, and then the short title and commencement clause 21. Honourable members, any other comments before we step off the National Forest Amendment Bill?
None from our side, Chair.
Good. Thank you. I take that then silence as confirmation that all the members are happy. We will come back to this within, hopefully next time, the input of the National Department as well as that of Advocate Master. Honourable Maseko?
Yes, you are right, Chair.
Good. Thank you very much. Honourable members,
Thank you, Chair.
That I'm glad we could deal with the easier one of the two, the one that elicited less public response. And I do hope that this has now set the pattern for us also now to go to the National Environmental Management Laws Amendment Bill. Any comments on our strategy and way of working, suggestions for us to improve on our operations? I recognize you, Advocate Master.
May I then be excused from further participation, Chair?
You are excused indeed, and thank you very much for your contribution and also for going away with the homework that we've left with you. Much appreciated, Advocate Marstal.
Good, so Chair. Thank you.
Thank you. Thank you. You go well. Good. Good morning. I now welcome Advocate Andre Leroux. He will be dealing with the National Environmental Management Laws Amendment Bill and assisting us in this regard. Advocate Leroux, I do hope you've been able to follow the last bit of the meeting now on the National Forests Amendment Bill, and that you would be able to also fit into our way of going through the bills clause by clause. Perhaps you could just say good morning to all the members.
Hi, good morning, members. I trust everybody's doing well. Yes, I listened to the last part of the meeting, and I am happy to proceed in the same way.
Good. Good. Thank you, Advocate Leroux. Honourable members, I do trust that you now have in front of you the National Environmental Management Laws Amendment Bill. It speaks to a number of pieces of legislation that it aims to amend. And quite frankly, I don't have all those principal pieces of legislation open on my computer at the moment, although they are here, and it won't be a problem for me to open them. And perhaps we can take a short break between some of them. And then you will hopefully have the bill in front of you. You will hopefully, as we get to those pieces of legislation, have the main piece of legislation in front of you. For the bill, it's the 14D version that you must please consider. And then there's also a matrix which Ms. Nika kindly put together. And let me just quickly find that one here on my computer with the feedback on the NEMLA, National Management Laws Amendment Bill. And quite frankly, I must now close, or I think it will be easier for me if I now close all the pieces referring to forests and go over to, if you just give me a moment, away from forest, NEMLA Bill. And in terms of NEMLA Bill, there's a document called NEMLA 4, which is the Western Cape Department's, let's see if NEMLA 4 is open. It's a PDF document. Yes, I have it here. I have two documents from the Western Cape Department of Environmental Affairs to also consider their input. The one document, I don't know if I added the words February 2020, NEMLA, Western Cape Depth Environment Affairs Submission, Feb 2020. And the other one is NEMLA 4, Table of Clauses 28, 2020. Good. And then there's also the document, the matrix document, which was drafted by Ms. Shireen Necker. I just want to make sure that we're not referring to documents which you don't have or which you're unable to access on your site. Just the word matrix. There it is on my computer as well. Good. So, honourable members, similar way. Again, I'm going to refer to clause 1, 2, 3, 4. Then it's the bill. And when we speak about paragraphs and sections, then we speak to the principal bill. Now, in terms of the first few pages, if on the one page is, first page is the name, the second page says bill, and then obviously there's the reasons for this bill. Then on the page with the number 3 at the top, right in the middle of the page, right in the middle of the two margins, there's, for example, a thing which says Section 28.4 directive may also be issued to an owner of the land, a person in control of the land, or a person that has a right to use the land in question to empower then people are saying the word "the" should be there to empower the Director General of the department responsible for mineral resources and mineral managers. So perhaps if we could just highlight that somebody, Western Cape, and I don't know, Ms. Niekerk, whether it's going to be Advocate Leroux, somebody just goes through this to try and look for such, I almost want to say, grammatical improvements that could and should be brought about. Good. That, honourable members, bring us then to clause 1 on page 5. And our Western Cape Department of Environmental Affairs and Development Planning proposed an amendment in the sense that they also want the inclusion of a definition for the term environmental authorization. Mr. Mohammed, would you like to comment on that one? And do you have a definition for what you believe should be suitable for environmental authorization, please? I'm just going to switch my mic off again because I hear the refuse.
Mr. Chair, can I ask Mr. Hardcastle, because are you reading our comments that we provided to you most recently? Just to check again. I'm not sure which of your documents. We've really been inundated with documents. Okay. Because what
so it's difficult to keep track.
Okay, in the comments that we provided, I think you mentioned, I think it was the February, the 02 version. The February, when you mentioned the documents which you had open in front of you.
Of which the February 2020 was one, correct?
Yeah.
I see Mr. Hardcastle's hand has been raised. I recognize you.
Because we provide an explanation in that clause, but I'm going to hand over because we do say that we want to talk about we want to talk about environmental authorizations used in the Act and not just in Chapter 5. But Paul, if you can come in and just clarify.
Yes, thank you, Chair and members. Good morning. Yes, it's not so much a definition for environmental authorization that has been defined in the Act. It is rather that environmental authorizations is not only limited to Chapter 5. Therefore, it's more correct to refer not to Chapter 5 but to the Act. But it's not a new definition for authorization because that has been defined. But it must not be limited to Chapter 5, but to the Act as a whole.
Good, thank you. I do see in my notes, proposes amended definition of environmental authorization, remove Chapter 5. Now, it seems to me we need then a new paragraph, we need a new paragraph in the bill to remove the reference to Chapter 5 in the Act. Am I correct?
Yes. Yeah, Chair. Yes. Chapter 5 must be removed. And Chair, maybe just confirm, and Michelle Mellom can just confirm the date, which the latest, because the February comments was probably from this department, but the Western Cape as a whole's comments was submitted at a later date. And it will be more suitable to consider the latest comments that were submitted by the department, by the Western Cape government as a whole. There is not a lot of differences between the comments, let me make it clear, but there's maybe 1 or 2 additional comments that came from other departments other than ours. And and the clause by clause comment document was also requested by this committee. And that's the other document, yes. But maybe Michelle can just clarify the date of the comment.
Good morning, Chairperson. Michelle Mellom here.
Morning, Michelle, and welcome. We're listening.
Thank you. The most recent set of comments submitted to your committee was submitted on the 5th of August. And the comment relating to the proposed change to the existing definition of environmental authorization appears on page 2 of the template, which is attached to that set of comments. And the heading to that comment is
Stop, please, stop. Won't you just tell us what is the name of that document?
It's called the Western Cape Comments. Western Cape Comments on the National Environmental Amendment Laws Bill. That was the title of that I have.
WCG comments.
That is
NEMLA
correct.
4.
5 August.
No. How's that in a PowerPoint presentation?
Chairperson?
Please help.
Okay. The latest comments, as Michelle just said now, that was sent through to the committee is incorporated in the matrix. So if you look at the matrix for NEMLA,
again, please.
On page 8.
It would help us all. Stop. It would help us all if you could just, if you refer to any document, if anybody would just please name that document first before you go to other terms or other pages or on page this or that. We're sitting behind the table. We're not able to beam these things up all simultaneously. So please, don't say the name is the Western Cape government. If the name of the file was WCG, please, we must help each other in that regard. So please, Ms. Nikak, you say we don't need to look at that WCG comments because that has all been calculated and taken up into something which you call the matrix.
Exactly, and the exact document name is SC Agri and Environ -matrix -NEMLA.
And it's Microsoft Word document format.
Chair, maybe I can try to put it on the screen if you like. I don't know.
Yes. Can I just ask, are the officials, are they also in possession of that matrix? Because it no use, they refer to one document and page number, and we're sitting with another document with other page numbers. And please, I'm just trying to get us all literally on, or by speech, on the same page.
Chairperson?
Ms. Mellom, do you have that matrix? Yes, thank you, Honorable.
Chairperson, I think, yes, thank you very much. I think even if maybe the department doesn't have the matrix document, but as the matrix that our procedural officer have compiled it, it will make sense to them as she puts that on the screen that they know, and then they can talk to that.
Okay, good. So I'm going to close now this document which says WCG comments in a PowerPoint format, because I've been told that all that information has been carried over into the matrix document.
Yes, that's what she's saying, Chair.
Correct.
Chair, can you see the document?
Yes, we can see it.
We'll switch on.
Okay, great.
We'll switch on the incoming video now. Yes. Good. Okay, wonderful. Can I just ask the officials, do you also have access to this document, or are you going to follow on your screen?
Mr. Chair, we do have access to the document. We did receive it, and Paul did circulate the document now amongst us as well. So we are
Fantastic.
also, yeah.
Okay, good. Thank you. I'm glad I could get us all on the same page. And again, I want to say thank you very much for Ms. Nikak for the considerable work that she's put in getting us all on the same page and for putting this matrix together. Good. I see a number of hands still being raised. Ms. Mellem. Ms. Maseku.
Apologies. Apologies,
Yeah.
Chairperson. I didn't lower my hand, but it seems that the confusion has now been sorted. Thank you.
Okay, good. And I wonder, Ms. Niekerk, would you be able to then just somewhere on that electronic page, because I haven't got that page in a printed format with me, or just say accept or agreed?
I'll do that, Chair.
Excellent. Okay, good. So that is then dealing with that in clause 1. If we go down, the Center for Environmental, in my mind, I've got it researched. The last R may be standing for something extra. They ask for consistency in the sense that it seems to me in clause 1, paragraph E, it brings in the term environmental mineral, then the word resource is scrapped, and petroleum inspector. Now, say that that term is not being used throughout consistently where it should apply in this document. Can we park that with Advocate Leroux to just go and as he goes through the document between now and our next meeting, just see if that comment is correct, and then highlight for us which of the clauses should be amended to get to greater consistency. Good. I take silence as confirmation. Good. Then the whole issue of financial provision. Honourable members, just for your benefit, what this requires, as you know, that when people do mining, obviously the environment invariably suffers, and mines continue until they are mostly no longer profitable, when all the minerals or whatever they were mining have been exhausted, and eventually another company takes over this faulty mine group, a company with lesser cost structures or cheaper, etc., until right at the end, the last person is normally liquidated, and then it has become a national dilemma. How do you deal with the environmental degradation, etc.? So now the idea is, and I don't think it's completely new, to set up a fund to compensate, to allow then where the company doesn't fulfill their obligation in terms of rehabilitation work, to then step in, and so that there will be money available to government then to eventually do rehabilitation work. Now, there's also a new term which has been brought in, which has elicited some comments, and that is the whole term of progressive rehabilitation, meaning that one should allow the mine to continue, if I understand it correctly, for 80 years, and only then raise the whole issue of rehabilitation. But as, for example, with an open mine, as they move along, that they must also do rehabilitation work and closure work on the older sites as they move onto newer sites. What has been highlighted is that there needs to be some protection for this financial provision that the mine groups must provide for. And I don't know if the department or advocate would like to comment on the fears that the public expressed that it's all very good and well to say that there is financial provision, but that the financial provision eventually may be depleted by the time it is needed most. Can some comment on that, please?
Chair Paul Hardcastle here.
Thank you. come in?
Chair, what you've now started is a broader discussion on financial provisioning. This is just broad comments therefore. Yes, the concern is highlighted about mining and financial provisioning related to mining. Now, just to be clear, Section 24PA has been added that specifically deals with mining, whereas the existing Section 24P has been broadened to deal with other listed activities other than mining. So you've got now a dispensation where you allow for financial provisioning for non-mining related activities as well as mining related activities. When it comes to mining, you are correct in saying that the concern was always that rehabilitation on the financial provisioning for rehabilitation has not adequately been dealt with. And what the Act is trying to do, and the Act in combination with specific regulations on financial provisioning that is in draft format, is to cater adequately for rehabilitation. Now, some of the key concerns, and you've raised them also, is one, is that there must be continuous rehabilitation as the mine goes along. So there's continuous rehabilitation. Then it's the end of mine rehabilitation on closure. And then also it is what they refer to as latent impacts. And that is one of the big concerns, is that how do you deal with impacts like acid mine drainage is the classical example that we all know of. That is coming to the fore years after a mine has closed. And now that is now becoming a societal concern, or the cost is not for the mine because that mine doesn't exist anymore. Closure certificates have been issued. And now who's paying for the cost of cleaning up the environment? So partly this legislation is also trying to deal with those, what they call post decommissioning impacts and latent impact. Latent impacts is impacts that only become known afterwards. And the question, yeah.
Sorry, I made a mistake. I'm sorry, and I have started dealing with what probably will come up later on as we go along. I realized as you spoke that we're supposed to only deal with the definition here, and whether we're happy with the definition, and whether there should be a definition for words like progressive rehabilitation, etc. My apologies. I unfortunately forced your hand now to go into the detail that's still waiting for us as we go along. If you're happy to park your input for the time being, and let's just, and it was my mistake. It's my mistake. I apologize. In terms of the definition, are we happy with the definition as it is there at the bottom of that page? Also, the words listed and specified activities seem to have elicited some responses from the public. But do you believe that this will give the department the necessary certainty when it comes to what I think companies might, come back to because it's got huge financial implications for them? From your side, financial provision, you want that one that's on the screen?
Mr. Chair, if I may, that is our proposal. Remember, there is a definition for financial provision currently in the D version of the bill. However, we are saying that it falls short of that. If I read from the screen there, it falls short that it will ensure that the financial provision is safeguarded against being paid out, whether in the case of insolvency of a mine or any other circumstance. So the current definition of financial provision as it stands now does not address that. So what happens is the mines go insolvent, and then we are left with a legacy of unrehabilitated land. And so that is what we are talking about here. So our recommendation to you is that you support this inclusion in the as our comment to the bill, that they need to include some degree of safeguarding of the financial provisioning. That is the proposal that we put forward that is serving in front of you now. So we want an amendment to the definition of financial provisioning.
Correct. Now, I want to take you back to early this morning when we started to say we cannot say we want an amendment. We must propose an amendment then. Advocate Leroux, happy that we have got a proposal that is in the necessary, that is a well-worded definition in what the department has given us. What is the definition?
Chairperson, I do not have a comment on the proposal by the department per se, because it seems to me like a sort of an operational suggestion, by which I mean it's in the expertise of the department. On your other question, Chair, of course it's for the committee to decide, but for my part, I would not say that it is necessary for the committee to propose an amendment to the NCOP, by which I mean a technical, actual drafted amendment. I think it's perfectly acceptable for the committee to make a policy proposal also to the NCOP, to say, listen here, we think that the following needs to be addressed. So I don't think it's necessary that there always be a drafted or a technical proposal.
Advocate Leroux, I think you were still struggling to connect when early morning I indicated that our representative in the National Council of Provinces indicated that in terms of the way that they deal with proposed amendments, is that our chances of being effective and of being able to make about the changes that we wish are just so much stronger when we do present them with what I almost want to call the final wording, or wording to the effect that it could be used on their side, because they as a committee of politicians are not equipped to really there and then draft the wording, or are able to put to words what the Western Cape would like to see in the bill, unless we present them with a draft wording for such an amendment. So please, you must help us in that regard. We at least afterwards would like to say, this is what we proposed. This is essentially what the NCOP then decided. So please, I know in terms of the Act, it says we may submit amendments to them. But, in court cases, it seems to me also as if, or even the judges favored provinces to rather come up with well-worded amendments for the NCOP. And Ms. Niekerk would be able to refer you to the court verdict in that regard. Okay, so can we park that one then? Because it seems to be clear that we support our department. I think it makes perfect sense that if it doesn't only apply to Chapter 5 anymore, that should be reworded. If you believe that even in the definitions already, there should be a clear definition for progressive rehabilitation, that we must try and put forward wording to that effect. Can we park it with you, Advocate Leroux, to engage with the department on providing us with such wording?
Chair, yes. Between myself and the department, I would suggest that if the department made the proposal, that maybe they come up with a, since they will be best positioned to understand the proposal they made. But yes, we can engage on that score.
please do between now and next week's meeting, please, if you could do that. Thank you. Then can I just say, the department commented and say it's proposed that a mechanism must be provided for in the NEMA that will ensure that the financial precision is safeguarded. Please park that one, because I don't think that mechanism can be in the definitions, if you agree. So we've got that one then. That brings us then to page 6. So it's now clause 1, and we're now then in clause 1 with its a subparagraph G, and the department could just comment on the Center for Environmental Research's proposal that sometimes that the option of an offset for damage done should also be included amongst the definitions or elsewhere in the Act. Do you have any support for the idea of offset? And just from my days in local government, developer is unable to provide, for example, enough parking space. He was allowed to offset that by a similar development somewhere else, and the two would be bound to one another, etc. Would the department like to comment on offset? So mine, and especially now that we're dealing with definitions. Mr. Hardcastle?
Chair, one of the comments that we did make is on the definition of mitigate. Now, and the proposal is that it should read avoid or where impact cannot be altogether avoided, alleviate, reduce, severe, rehabilitate or offset. So there we propose a definition for mitigate. And it may address the CER's concern. Offsets are currently being used, and it's being read as consistent with the principles of NEMA, in Chapter 2 of NEMA. But the proposal is obviously to make it very clear that that mitigation must include the whole, what they refer to as the hierarchy of mitigation, or the mitigation hierarchy. That it's not only mitigation, but it's also avoidance as the first step. Then you start to alleviate and mitigate, and then the last step, if you cannot reduce the impact or there's residual impact, the remaining impact, then you offset that impact. So that is the proposal. It's a very clear definition. I was hoping to get National's comment on this, because it's a bit more complicated, but I'm not going to go into the technical detail thereof, but yeah.
Good. Okay. Thank you. We've got it. And I think if I speak on behalf of the members, I say support. Good. Then if we can go to the next item, and I wonder, Ms. Likat, if you would be able, because I'm concerned that I might miss. Can you go to the next page? Page 11. Number 11. Not changing on my computer.
It's changing at mine, Chair. It's the clause 1, the rehabilitate.
Good. And the proposal there is that rehabilitate means to restore to the approved end use of land or facilities. Yes, that is the other interesting one, that they also brought in facilities. Can we say we support that as well? Good. Then the next one, to include reference to offset, the definition of remediate is supported. So we support that. The next one, just to, sorry, it's a little bit small here on my screen, participation. Is there any opportunity of you of making your view somewhat bigger, because the last two paragraphs are, that's good. That's good. Okay. That is supported. I can just say when they speak of black professionals, I do know you speak of other previously disadvantaged persons. I presume that the department is referring to women, for example, or disabled people. And I think that's a valid one. Can we say that the participation or the definition could be widened? That will carry general support. Then the next one, Ms. Niekerk, again,
Sorry,
it seems to me
sorry,
every time
Chair.
you move that the view is made smaller. Honorable Mateko.
Yeah, Chair, I'm listening to your interpretation of the black, and you say women and people living with disability. Is it not the historically disadvantaged rather than that explanation that you attached to that?
Yes, correct. So I think what you then say is that we ask that black rather be that there be a definition. You see, black refers to a specific paragraph there. That we from the Western Cape, that we would say we would prefer the term in section 2.4 QA that it should be rather previously disadvantaged people.
Yeah.
As I've said, this is not final. Please, the officials and our advisor, the legal advisor, please go and check whether that would be possible to be inserted in that way. Okay. Ms. Niekerk, I'm just wondering, get your text bigger on your screens.
Chair, there is a raised hand of Paul.
Okay, I'm just quickly addressing the issue of the screen that is so small every time. Won't you go to your table tools and for now take out the last two columns, which at least the National Department's response column. I think it would be quite easy to add a column later on again.
Okay.
So that half of our screens are not taken up by a blank column. I think take only one column out. The other one you can use then for the comments or for the support or not support. Okay. Well, she's doing that, or trying to do that, Mr. Hardcastle, your hand.
Chair, yes, just to confirm that the bill does include the definition for black. When used in, it refers to the Black-Based Economic, Broad-Based Black Economic Empowerment Act. So it doesn't provide its own definition. It refers to definition in that act.
Yes, which refers to people classified before 1994 also as colored and Indians. Okay. Good. Thank you. That then deals with that. I'm now trying to follow on the screens because I think that then we know that we're all dealing with the same paragraph. Ek nou jou goed die mekaar gekrap.
Ja, het nou heel die mekaar. Just give me a moment, Chi. I'm just going to unshare it and then do this.
Okay. While you are trying to undo what I just asked you to do, then can rehabilitate was the last one. The definition for progressive rehabilitation, have we finished the debate on that one? Then I think we're the black professionals of black professionals and previously disadvantaged people. Are we to deal with clause 2 already? Good. Take the silence as that you agree. So the full participation of black professionals and previously disadvantaged people. Good. Then in terms of, it seems to me, clause 3, there was just a very small proposed amendment there. It says the minister must keep a register of all environmental management instruments adopted in terms of this act and make it publicly available. there was a comment that it should also include a provincial MEC. Comment on that proposal, Mr. Castle?
Chair, yeah, no, it's just it wasn't a comment from our department specifically, but yeah, it just refers to in terms of it being a concurrent function, that it should not only be the minister but also the MEC that keeps such a register.
Didn't lead to unnecessary duplication. Can I just ask, what is a typical environmental management instrument?
Word doesn't want to work now, they're waiting for me.
Chair, there's a number of different instruments. It will be strategic environmental assessments. It will be environmental management frameworks. It will be generic environmental management plans. Okay. There's a number of such instruments, and some of them are produced by MECs and others by the minister.
Okay, okay. So I see that is in the definitions, but you say it will not be necessarily a duplication if the MEC has a register of the management instruments used in a particular province.
Chair, there's probably merits in both. If I'll be honest with you, your point about duplication is a valid point. There is much to say for one central unified database, but also that if somebody wants to be very specific in what happens in what province, then there is a provincial database also. It will probably be a little bit of a duplication, but yeah, so I don't know how to else comment on that, but yeah, it is duplication, but there's merits in both sides.
Okay. So members, can I get your views? What do you believe? Should we include the words the minister and provincial MEC must keep a register, or shall we just go with the wording as proposed?
Let's go with the wording as proposed.
Okay, good. Thank you. We then stick with the wording that we've got there in clause 3. Then in terms of 4, clause 4, A and B seems to be fine. C, there was also an amendment which says contemplated in, and will now read subsections 2 and 2B, and it was also proposed that paragraph 3 may be dealt with by the MEC. It seems to me I've now really Ms. Niekerk under the boat, under the bus. So would you just verbally comment on the comment to add a paragraph 3 may be dealt with by the MEC, Mr. Hardcastle?
Sorry, Chair, I was just now trying to figure out where you are. Sorry, I apologize. Which paragraph is it? The one under clause 3E?
It is clause 4C, and you will find a reference in line 32. Contemplated in subsections 2 and 2B, and there was public comment, and 3 may be dealt with by the MEC. And I think you said you were not sure if the MEC should be included. I think it's the paragraph that deals with a national priority. I'm referring to the bill, page 7.
Oh, are you now in the bill? Sorry, okay, I apologize. I'll go to the village clause 4.
Clause 4 on line 32. Yes, I'm sorry.
Okay.
In fact, the matrix has disappeared from my screen. That's why I referred back to the bill.
Yeah.
Chairperson?
Ms. Niekerk?
If I may, I'm going to go away for a while. I have to restart my PC because Word is not working. If someone else has the document open, if they could then share it in the interim while I restart.
Okay, let me just quickly say again, it's SC Agri and Environmental Matrix, NEMLA.
Not
Correct?
environmental, is SC Agri and Environ Matrix, NEMLA.
Oh, okay, it's the Environ 4. Thank you, sorry. Let me just get the right document up. Is there anybody else that would be able to get it up faster than what I would be able to? So many open documents. Mr. Hardcastle, you know what paragraph we're referring to now?
Yeah, Chair, is it paragraph C that you want, or paragraph B or C? Say again?
No, it's C. I'm going to read you again.
Yes, yes, I've got it. I've got it.
CA contemplated in subsections 2 and 2B and 3 may be dealt with by the MEC.
Yeah, Chair, a little bit of a long-winded explanation here is that the national priorities is based on two big B, and we are happy that they refer to subsection 2 and 2B, although that wasn't our first choice. Our first choice, and that is what we try to explain, this is already better. It wasn't like this in the past, but based on our comments, they've changed it so that even if it's a national priority, the Minister and the MEC can still agree that the MEC can deal with national priorities. Our first choice was, however, is that that the MEC should anyway be the first port of call. And then if there is an agreement between the Minister and the MEC, then the Minister can deal with certain applications. Because the argument that we had is that the assumption that if it's of national priority that the MECs or the provinces cannot deal with it is flawed. And there is also not criteria for what constitutes a national priority. So although we support the amendments that refer to 2B also, we believe that the first choice should be rather that the MEC, the provinces must be the competent authority unless agreed to otherwise in terms of subsection 3, and that's it. We support the amendment, but it's not our first choice. We believe that in terms of the concurrency of the environmental management functions, national priorities should not by implication be dealt with at the national government level, because that's a flawed assumption that provinces cannot deal with those. But if there is an agreement in terms of subsection 3 that the national minister rather than the MEC can deal with it, then so be it. And that should be done through cooperative governance, not by the stroke of a pen in legislation.
The question is, should the words and 3, section 3, should that be included?
Chair, I'll have to now, I'll have to quickly look at our comments and look at what subsection 3. Subsection 3 is based on that there's a general agreement.
Okay, can we park that one with you? We park this one, and we'll give you the next week. We can look at that one. Okay, then and again, I'm working from the hard copy, the bill. The very last sentence, the second last line, says an integrated decision may or must be issued. So there are two things which were raised with us The first one is whether the word integrated decision, there was perhaps integrated environmental authorization is a word that may have been used, and then the word may or must. Can we get your comments on those two issues?
Chair, yeah, I just wanted to get our comments in front of me quickly. There's the two comments. It's the consistency is that it's an integrated authorization, that we must be consistent in referring to authorizations. And also the must should be a may, because we believe that there may be practical realities that makes it very difficult for such an integrated decision to be issued, and we proposed more flexibility in changing the must to a may, to cater for a complication that we may not anticipate at the time or now, but that may exist, and we do not want to complicate decision making unnecessarily by saying, but now we must issue that integrated decision. By all means, the effort must be there, but to create flexibility, we said it should be a may.
Good. Thank you. And it remains the words integrated decision.
We propose integrated authorization.
Yes, good. Thank you very much. There was, on the next page, which is still dealing with it's clause 5 now. The Centre for Environmental Research was that people might start activities without environmental authorization. Now, here it is, when people have commenced, undertaken or conducted a waste management activity without a waste management license, so my understanding is these are people that are now, I almost want to say, outside of the law. And now it seems to me this clause wants to prescribe or direct what should happen then when people have just started out first getting the necessary approvals, etc. They are concerned that this process will now encourage people to break the law and say, well, breaking the law has been provided for in legislation. Would you like to comment on that?
Chair, you're now dealing with CER's comment. I'm sorry, I'm
sorry, I don't have your comment in front of me now, because the document I have and the one that was on the screen wasn't quite the same. So I've referred back to the bill now and the issues raised when the public addressed us on the bill. And this is now section 5.
Okay, Chair, I can come in there. Excuse me. So although 24G was originally envisaged to be an amnesty process, we do have the situation where some people do break the law and they unlawfully commence with activities. So we need to accept that reality, whether it's by willfulness or whether they just didn't know, or by ignorance. That is the reality. And there is no other way to then legalize or make something lawful that has been unlawfully commenced with. And 24G is that opportunity. So it's like, I always compare it to a speeding fine and the payment of the fine. If you don't pay the fine, then you're guilty of the offense. But if you pay the fine, then you admitted guilt. Although in 24G, you're not admitting guilt. So we need something like this. In terms of the 24G regulations, because it comes out later again in the CER comment, it does not mean that they are absolved from, the perpetrator is absolved from criminal sanction. that can still be pursued against the unlawfulness. But even if you do the prosecution and you successfully prosecute them, that still does not give them an environmental authorization to continue with the activity, because the word continue comes into 24G later on again. So either commence or continue. So our argument from a legal law to create a legal mechanism to deal with that stuff is that we do need 24G. We cannot say that we're going to scrap it, because then everything that has been commenced with unlawfully either has to be rehabilitated, and sometimes that is not realistic or practical, and it might cause some more damage as well. But those options. So we really do need something like this in the law, and it creates an opportunity to bring people into compliance. The fine it's currently at 5 million, and the fine is up to 10 million. So the fine must be the deterrent for not having to commence unlawfully. It's not necessarily, the arguments are made that sometimes it's cheaper to do a 24G. That depends on the process that they have to go through. So it's a here and there argument in terms of people will then budget for it. Even if they budget for it, it doesn't mean that we will grant the authorization in all 24G instances. We can still refuse the development and instruct them to rehabilitate. So there's a major risk here that they will take in terms of going for the 24G route rather than the normal route. So our argument or our response into the Center for Environmental Rights and some of the other organizations is that we do need a mechanism like this, because we need to find a way of rectifying the unlawful commencement of activities.
Okay, thank you very much. And then if we go then to the bottom of page 8, there you've said that the words "if applicable," that is now in the new DD, and also the whole issue of an environmental management plan, EE. You felt that the environmental management plan must be put separately. You could just expand on that, Mr. Hardcastle. First, the issue of applicable, the description of the public participation process followed if applicable. You said that seems as if it's making the public participation process optional one.
I think if I can come in there, Mr. Chair, it's also this will, if we delete that, then it imposes the public participation process, which must be done in the normal applications on an applicant in that regard. So we don't want to make the process any easier in terms of 24G, and hence that proposal that we say if applicable must be deleted, because otherwise you will have some discretion. And in that way, people might then see that 24G is an easier process to follow. So that's why we recommend that that in terms of those clauses, the word "if applicable" gets deleted. So they have to go to the prescribed public participation process.
There must be public participation. Good. Yeah. I think we will support that, and the members must comment if not. And then your comment on the environmental management program.
Chair, we're not taking it away. We believe it is better drafting just to put it as a separate, and it's not part of the report that is compiled, so it's a separate provision. It improves the governance thereof. So, but it's not taking it away, it's simply making it a separate provision.
Can I just ask, if I read the wording correct now, it says there under G, and that is now in page line 37, compile a report containing, compile and. It seems to me also like bad formulation. Compile a report containing, compile an environmental management program. Please with a better word. Compile a report containing. Surely the word compile must then disappear in EE, but how would you like the final wording to carry to the NCOP?
Chair, then it would be a separate, it would not be an EE,
Yes.
it will now become a new 8. So it will stand on its own as a separate provision.
Okay. So EE, we propose that EE be deleted. And you want then a separate, you say, 8. Also under section 24G?
Yeah.
Now, you say a new 8, you must now help me. Do we have a 607? Is that in the main?
No, Chair, we can actually leave it. All that we are saying is the word, like you are saying there, the and should come out. And our problem is the and, because that and makes it peremptory, which means you must do everything and you must compile the environmental management program. So your wording is correct in terms of we need to take out the compile because it's already included in the start of paragraph G. So we want and to come out. And like you say, it's not drafting, it's bad. I mean, it's bad drafting that they said, and we did make that comment up front. So we're just saying that the environmental management plan is then is a separate because it's not an and.
Okay, I'm not with you, but please, if you could just next time around give us the necessary paragraph number so that when we come back to this, that we can just have the complete thing from the numbering right through to the very end. Okay. Then there was I'm on page 9. I don't know if Ms. Nikak's screen is up again. Thank you, Ms. Nikak. It's definitely more readable. Thank you for your trouble.
No problem.
I'm now with the top of page 9 of the bill, F, where it says may direct the applicant. And the words were proposed, request or direct. Now I must just go back to Ms. Nika's document. You want us to be now. I'm still with clause 5.
Okay, Mr. Chair. The way it works, when they say direct, and then you need to issue a directive, and a directive is also appealable. And if you issue a directive, it's like an instruction, and you need to do give them a PAJA notice. So all that we're saying there is we would like to have a request, because there are instances and the example that we gave there was, for example, where somebody just didn't sign the application form, and then we need to request them. So we're just asking that there's a little bit more flexibility so that we can get administrative procedures, we would be able to capture it, and that we don't have to direct them for new information every time. So it's just a practical arrangement that we would like to put in place. Yeah.
Okay, Ms. Nikak, you must now just help me in terms of clause 5. I almost want to say the almost last input there, request or direct. Where do we see that wording now in terms of the matrix? Sneaker, where do we see?
I'm here, Chairperson. If the department can
request or direct.
Yes. There's the clause 5, new proposed.
As members, we as members support that. If I can speak on behalf of the members now.
We are on the top. You are right there. That is where we did with we dealt with the environmental management plan, which is the earlier on that we did that. And then so you are at the right place now, Ms. Wendy.
No, thank you.
Well, we'll see. Where do you see the direct now? Request or direct? Because that is the issue now. She captured that. Must you scroll slightly down? It's still clause 5.
There we go. It's there now. Proposal, it is therefore proposed at request or inserted before direct. As you are reading on the screen there now. So that is the section that we're dealing with now.
So she can just type there, accept it or something like that. Okay. Yeah. The next one is then...
Chair, pardon.
Please help.
Okay, I think everything that can go wrong is going wrong because I've just been kicked out of the meeting on numerous occasions now. But it's right here. If you look at the screen where the department says it is therefore proposed that the words request or are inserted before the word direct in section 24G1.
My problem is just that the screen that I am seeing, okay, there it is. There's therefore proposed that the words request or are inserted. Okay, and we're in support of that. Right, that's good. Then the next one is the issue of a fee versus a fine. Sorry. Okay, and we say a fee. We're happy with that. We would like the word a fee to be included. Agree?
Yes, sir.
Thank you. So, Mr. Kerk, you will somewhere keep note that that has been agreed to. Then the next one is the increase in the fines. That's also supported.
Yes, sir.
Then the next one. Provision to close. Oh yeah, there was also the whole issue that applications should not stay open, but it should not stay open indefinitely. There must be after 3 months or 6 months, an application should be should close. Okay, so 6 months is the period that you propose. And can I again just ask, is it a paragraph that you would like to be included, and what would that paragraph number be?
Chair, the paragraph number has been given there.
1B1.
Yeah, so so that is that's fairly clear. That is what we want. So that we cater for the lapsing, and I think this was one of those that I was very interested to see what National's comment would be, because I mean they said that I saw it for the first time, although that's not true. But yeah, so this is the proposal. Yeah, I think it's very clear.
Okay, can I just ask, is that still under clause 5?
Chair, I'll just check quickly under the...
Yes, it appears to
yes.
be, yes, it is, because clause 6 deals with the amendment of section 24N. So this still falls under 24G, which is clause 5.
Good. Thank you. And as I've said, we just need to be able to give through to our member in the NCOP the clause numbers that we would like to either include or amend, etc. Okay, so that deals then, can I say then clause 5 has been dealt with, and we can go over to clause 6. Thank you. Is that demolish and remove? Clause 6, there we are. Okay, in clause 6, if I recall correctly, that insertion which is proposed by the department, something which we should contemplate taking that completely out and rather include that in regulations. Am I correct?
Chair, that is what the amendment is proposing, is that 24. Let me just. Yeah, 24N dictates the content of an EMPR environmental management plan. Whereas the environmental impact assessment regulations also contain, as one of its annexes, the same information. So what to rationalize the legislation, what National is proposing is take away or delete all the content requirements of 24N. What we are questioning, and we are posing the question, is there unintended consequences of deleting the requirements in the Act and only relying on the subordinate legislation, the EIA regulations, to govern the content of an environmental management program. Other than that, we don't have any concern about the deletion of that provision.
Okay, you must please help me. So the final position is, are we in agreement with the department removing that paragraphs A to G, or would we like those? You say the implications of removing it must be considered, but what is your advice to us? Must it remain?
We are accepting that it can be deleted, Chair, and that just the unintended consequences. So there needs to be a check. National will have to do a check, and we can also do that check to make sure that the word, because the word environmental management program is defined as we just, or is stipulated as we just discussed now under 24G. So if you take it out of there, then you must just make sure that it there isn't a cross reference. But the way I understand the logic now, they've included it in 24G, so it can actually then come out in clause 6, because they've got that now stipulated under 24G. So they have covered that basis. So I think we can support the removal of those content requirements of an environmental management program.
Okay. Thank you very much then for that one. Honourable members, I'm going to give us all a little 10-minute break at 11 o'clock, if it's fine with you. There is some background noise from time to time. I know we can't always control that, but please mute yourself if that is the case. Good. Then the next one, clause 7, the insertion of the provision that the consultation concern may be done by a EP. I see that all these terms that you use, environmental assessment practitioner, and it says the word there, it's likely to shorten the process and make it less expensive, but there was 2 comments that I can recall. The one is the whole issue of State Department. It was proposed that the word every State Department must be rather replaced by organ of state to also provide for municipalities. I don't see that. Oh, that's clause 7. There you've got it. Okay. So the word organ of state, and the other one is an environmental assessment practitioner must consult with every organ of state. And the word consult, are you happy with the word consult, that everybody knows what is meant by consult? If you consult the municipality, they don't respond, you can still claim you've tried to consult with them. So please, department, help us on those 2.
Chair, there's 2 aspects here. We are happy with the consult because we cannot be held ransom if simply comment isn't provided. For the sake of good administration and good governance, we need to be able to proceed. So we're comfortable with consultation. And also when related to organs of state, it's also that there's certain non-state departments that also administer legislation that is relevant to the EIA process. That may be in conservation body like Cape Nature or National Parks Board, even a municipality. and those are organs of state. They are not state departments. So we are proposing that it should correctly refer to organs of state and not only state departments. That's the one point. And then in the other one is that support for the EAP to consult with organs of state. And I know that the CER, for instance, was, or I can't remember if it was the CER that had a problem, and that the state cannot abdicate its responsibility. But what we are saying is that that doesn't mean that before making a decision, the state department must also consult. But what happens is that issues must be raised, what the EAP must consider in the EIA process. If the state departments now only comment to, or the organs of state only comment to the competent authority, then the EAP may not consider that issue because it wasn't raised. So, and that it means that the impact report would be inadequate because they missed an issue. So if the EAP can now directly consult with the organs of state, that makes the governance of the EIA process much more acceptable. You'll cut down on red tape, meaning that the report has to be referred back to the EAP to update. So this is just good practice that is currently actually taking place. And this is just putting it in legislation. So we support the reference to EAP must consult, and but it must be with all organs of state or relevant organs of state.
Good, thank you. Agreed to. This brings us to clause 8. One of the things that I saw that you said you would like the heading, which is provide financial provision for remediation of environmental damage. We should perhaps delete the words for remediation of environmental damage to make it, I presume, a little bit wider. Can I just comment on what is put there in bold on the bill?
Yes, Chair.
Am I correct?
Yeah.
Good. Okay. Then the next one brings us then to 24P. And there have been quite a number of changes which you've proposed in that regard. Would you like to speak to it, please? Have I been cut off? Do you hear me?
Sorry, Chair. I was speaking in a mute. I muted myself. I apologize. Okay. Chair, I just want to get my comments out so that I make sure I cover all of them. And this is what I was actually referring to earlier. Is just we need to understand the relationship between Section 24P, which is the old Section 24P that they've amended, and then they've added a new Section 24PA. So 24P now refers to listed and specified activities, and it can include mining, but 24PA is very specific only to mining. And there's a number of issues that we now need to consider. First of all, we just wanted to clarify the relationship between the other two. And now we don't have we posed a question kind of that we just make sure that there is not a misunderstanding of the relationship between the two. And then I think one of the key comments that I want to make is that that they are proposing in 24P, I think it's P4, where prescribed, an applicant must provide financial provisioning. So prescribed mean that it must be captured in regulations. So we wanted to have more flexibility. Whilst there is for the mining legislation our regulation, or for the mining dispensation, there is regulations for financial provisioning. There isn't for listed activities other than mining. So what we wanted is more flexibility. So we propose that it's not only where prescribed, or where specifically required by Minister or MEC that the applicant must make financial provisioning, so that we can apply this clause and not only wait till there's regulations before we can apply this clause to non-mining activities. For instance, there may be a significant industrial development that will result in major implications, and you want financial provisioning to be in place, but now because there isn't regulations now, it's going to take a while to produce those, you cannot use this clause. So we want more flexibility by adding that wording. That, I think, in terms of 24P is the major issue.
Sorry, can I just quickly stop you there? So you say, for example, if I understand you correctly, if somebody wants to undertake huge, let's call it, you said development. Let's say, for example, you get permission to build a dam, and there will be some environmental impact there as well. And afterwards, there must be some rehabilitation so that the site isn't left behind in a bad state. That you would, it seems, and also would like to be able to say, but as part of your construction work, you must also put some money aside so that the moment you leave, there was enough money eventually to rehabilitate. What kind of other activities?
Yeah,
Okay.
there's 100.
Okay, good.
That's a very good example, Chair. It's exactly that.
Okay. Now, so what are the changes that we want in the wording of those paragraphs? And can I also ask, one of the interesting things is it says where prescribed, an applicant determine the financial provision which is required for undertaking progressive rehabilitation. So it seems to me the mine company or the construction company, the civil works company, they can determine themselves the amount of money needed to rehabilitate afterwards.
Yeah, Chair, they will propose something, but the competent authority must still accept that as acceptable as part of their decision making. So they would require something else, or require evidence on which you base the amount that has been set aside. So there would be some work that needs to be done and motivation given, and a competent authority may say, no, that's not acceptable, good enough.
Okay, good. Thank you. Thank you. Can I just ask, the wording used, for example, in subparagraph 4 and later on as well, they speak of where prescribed the applicant, comma, holder of an environmental authorization, comma, holder, comma, holder of an old order right. So that word holder there in the middle, what does that refer to? Where prescribed the applicant or a holder of an environmental, or holder of an old order right. Now, my impression is the old order rights, these are old mining rights, where people were given certain permissions. And obviously, they fall under a slightly different dispensation. But that holder in the middle, and shouldn't the word or be included, because you can't be an applicant, a holder, and a holder of an old order right.
Yes, Chair. I haven't looked at the or now, but it sounds, yeah, it must be sensible. You're right. Holder of an old order right. Look, an applicant is somebody that apply, and a holder, it will be the holder, the current holder of an authorization. But the holder of an old order right refers to the mining dispensation, because the old order right refers to mining rights that was secured under the previous, before the One Environmental System came into being. Now, hence our question to the national government was that they just clarify the relationship between 24P and 24PA, because 24PA, according to us, is absolutely only mining. But then 24P also got remnants of mining, like that old order right, included in it. So we wanted to clarify if that was correct or not, or are we missing something? So we don't have a very specific proposal. We just wanted them to clarify the relationship between the two. So yeah, but the old order right is mining, and the holder refers to a holder of an authorization or a holder of an old order right, for that matter, also pre the one environmental system.
And do you believe that if we receive the comments from the National Department, that would hopefully clarify that question that we still have?
Yes, Chair, I was hoping that would be the case. I can't guarantee that it will be, but yeah.
Okay. So we park that one, and we will be looking out for that one. Mr. Mohammed?
If I may, Chair, just before we break, there is quite a few of these things where we actually need the National Department's input, because it's a matter of approach, and do they agree with our approach or not? And only in terms, then we would be able to move ahead and debate the matter further with them.
Okay. So we lament the fact that we don't have this, but I do believe that we are still using our time constructively. Honourable members, we've been going for 2 hours, and I want to say thank you very much to each and everybody. Shown great restraint and discipline to be here. Can I ask that we break for some 10 minutes, just to have a leg stretch? Please don't log off. Can we rejoin? My phone is saying it's 2 minutes past 11. Can we then say 12 minutes past 11, and then we will continue until 12 o'clock and see what progress we can make in the last 45 minutes? Silence, I take as confirmation. Thank you, honourable members. We see it's other 12 minutes past 11 again. it's 12 minutes past 11, so can we reconvene and continue with the discussions? We're on clause 8 of the NEMLA bill, and we were discussing the issue of the rewording of that, including the insertion of the word or, and then there's also that the replacement of an old order right is required to, the word is required to be replaced with must. Can I just ask, is Mr. Hardcastle and Mr. Mohammed back again?
Yes, Chair, we
Yes, I'm here.
Good.
Yeah, it's, Chair, the is no must. It was just better drafting to draft it that way to provide clarity. It's not a major issue. Chair, I just want to go back to one thing maybe that we passed on, and that is the definition of post-closure. And this highlight the issue to the Standing Committee is that the concern that we raised all along is that what is meant by post-closure and how long after the closure of a mine is financial provisioning to be catered for. In other words, is it 10 years after the mine? Is it 20 years after the mine? Or how are we going to ensure that adequate financial provisioning is going to be made to continue post-closure monitoring? And if the monitoring does pick up an impact, that there's adequate financial provisioning for such, for addressing such impact. Now, you cannot make it ad infinitum, I suppose, but for how long is post-closure financial provisioning to be provided for? And we've asked clarity from the national government.
And we're still waiting for their response. Unfortunately, we don't have it today. So you're just highlighting that again with us today. And we do hope, and perhaps we can ask, once we receive their response, and if they don't respond on that specific issue, that we don't wait for our next meeting, but that you would say this committee would like also to get clarity on post-closure term. Please, if what we can deal with outside of the meeting would be wonderful. Good. Are you ready for us to go down that page to 24P7, or are there any other issues that you would like to raise before that as well? Oh, you also requested norms and standards for that provincial financial provisioning. You know, what must be covered, because obviously one will have to accept that there will be some costs remaining.
Yeah, Chair, what we're proposing there is simply that an enabling provision be created that allow the minister to draft norms and standards so that there's some form of consistency in how it's approached. Now, so it's rather discretionary, but it will then provide some consistency. So it's just to provide an enabling provision, and we haven't drafted such an enabling provision, but yeah.
Okay. And the ease is a must. With that, we in all, I think, in agreement.
Yeah,
somebody.
Yeah.
Okay. That brings us to that subparagraph 7. Then the financial provisioning vehicles contemplated in Section 6 may be used in combination as required. Then under 8, I've just got a point where it says where the Minister for Mineral Resources or the MEC is not satisfied. And, you know, ministers, I almost want to say names, change from time to time. But I was just wondering if we shouldn't say something where the minister responsible, or ministers responsible for mineral resources, water affairs, you know, because, you know, sometimes water affairs are with sanitation, sometimes they're with human settlements and so on. And I don't know if it's good legal terminology to say the minister responsible for mineral resources, minister responsible for water affairs, if they are not satisfied. I don't know if Advocate Leroux would like to comment on that. But you also want water affairs to be included.
Chair, I'm not sure that it's intended to apply in respect of water affairs, but so the minister is defined in the Principal Act to mean to refer to the minister responsible for environmental matters. I'm not sure that addresses your concern.
Okay. I think generally it's accepted that, but you know, sometimes we speak of the Minister of, let's say, mineral resources, or then it used to be called mining, etc. And that is why I'm just concerned when we link what could be like a title to a minister. And the interesting thing is that actually in the next paragraph, paragraph 9, the drafters of this speaks of the minister responsible for mineral resources. I just thought that perhaps being consistent in the words being used is good. And then secondly, I think from Department of Environmental Affairs and Planning, Western Cape, they said, but you know, what about the minister responsible for water affairs? Because quite often the effect of this is also on the water that we would like to use. Mr. Hardcastle, I see your microphone is on.
Yeah, Chair, so obviously I think water affairs is also very important, but I think that what we also refer to is that where the clause is referring to the minister not being happy or not satisfied with the review. But that specific wording, we're concerned because there isn't an enabling provision in 24P that requires the review. So the comment that we made also is that you must have an enabling provision that trigger a review, and then that provision that the minister is not happy with the review makes sense. But you must first enable the review, and then the minister can express a view on he or she is not happy with the review. So that is the comments that we've made there.
Just help us with the subparagraph. Where would you like the words review to be included?
Chair, what we are saying is that there must be they must create a new clause, sub-clause that enables a review to take place. Because they say yeah, so that's what we are proposing.
The preferred place for the insertion of such a sub-clause to make the flow of reading of the bill better? Where would you like that sub-clause to be included?
Chair, probably I'll have to quickly look at that, but it will probably be before the provision that refers to the ministers not being happy with the review. Chair, what I can do is when we come back on next week, I can propose a specific where it should be. I just don't want to now waste time.
Okay. Good. No, please, and it will definitely. It seems to me to be before 11. Okay, and you will come back also with that minister responsible for mineral resources and water affairs, that include that there. Okay, good. Then can we move on to clause 9, or are there any outstanding issues regarding clause 8 for us still to consider? Clause 9 then. Thank you. Then you felt quite strong, well, not strongly, but you proposed that the financial provision must be in South African currency. Would you like to expand on that?
Chair, that was actually not a comment from this department. It was a comment from another department within the Western Cape government. But they just posed a question that it's actually silent on the issue about currency. What if there's international companies? We kind of assume that it refers to South African currency, but it's silent on that. So I don't have a very strong feeling on this. But the question is just clarity. Are we talking about financial South African currency? Yeah, it's a question of clarity. The answer would be very quickly probably yes, and then so be it.
I think the important thing is we wouldn't like that provision to be offshore. We want that provision, that fund or that guarantees or that money being set aside. We would like that to be within South Africa and not to be in Dubai. Is that actually the point that we're trying to achieve?
Chair, the comment, if I remember correctly, was only questioning in which currency it is. But the point you raised is of obvious importance. I agree, and that is that it must be within South African. Must be subject to South African legislation in how it is implemented. So without doubt, it must be subject to South African law.
So again, can we ask you to just go back and see, whether there's enough provision to, and we think of recent examples in South Africa where he left the country and where some of that money may have been money that was supposed to be set aside for mine rehabilitation, and that we just make sure that that is now covered within the bill. Good. Thank you. Then can we, that deals with Clause 9, Clause 10 seems to be good. Clause 11, the repeal of the Section 4S of the NEMA is supported, which brings us to Clause 12, if I'm correct. And here we've had a comment from the City of Cape Town that they believe there is some uncertainty regarding the, did I write communication?
Chair, I'm not. I'll have to just check the City of Cape Town's comment quickly. I haven't looked at it. I just want to check see if I can pick up the City of Cape Town's comment. Chair, I don't see this City of Cape Town. Sorry, I want to comment on it, but I don't have it in front of me.
Okay, I'm just writing here parking. We've parked this one. Okay. That brings us to, in terms of section Clause 12, which deals with Section 28. You've had quite a number of issues there. For example, the environmental assessment includes also strategic environmental assessments. Perhaps you could just explain to us the word strategic environmental assessment.
Chair, yes, I'm just trying to figure out where I am now. Let me just Chair, which clause are we on now? Sorry, I apologize. I just
no. I understand. I fully understand. It's difficult for us being in different rooms to be on the same page.
Which clause are we dealing on? Let me just go to the act itself.
Yeah. Can I just say, it seems to me it must come in between clauses 11 and 12. That you said there's a Section 25E
you
referred to.
Sorry, Chair,
which is not dealt with in the bill. That's why it's, sorry, it's between 11 and 12.
Yeah.
It's
Okay.
an amendment that you are proposing that is not currently in the bill. It's a new additional amendment. And you refer to environmental assessment, but then you say it must include also strategic environmental assessments.
Yeah, Chair, yes. I'm desperately looking for our clause, but the issue there is that if you look at an EAP, it is somebody that does an environmental impact assessment, but also strategic environmental assessments. Strategic environmental assessments is where you're not doing it for a specific project, but you're doing it for a much broader area. For instance, the national government has done a strategic environmental assessment on shale gas a while back. It covers the whole of the Karoo and the environmental implications at the strategic level. We say that, and that it must also relate to environmental assessment practitioners must be registered, and anybody who wants to do an SEA, a strategic environmental assessment, must be a registered environmental assessment practitioner also. And it's not only related to EIAs, if that is the comment that we are referring to. Yeah, so that's where strategic environmental assessment is also important in terms of that the quality thereof must be governed, and that it must be specific registered EAPs that must conduct a strategic environmental assessment.
Is the word strategic environmental assessment defined?
Chair, I don't think so. You now caught me off guard.
It is one of the,
I don't.
Well, it will be one of the environmental instruments as well.
Yeah, it is. It is an environmental instrument. Yeah, sorry, I apologize. It's one of the environmental instruments that's included in a definition of environmental instruments, but it's not legislated through regulations or anything. It's a voluntary tool at this moment in time, a voluntary instrument.
Okay, thank you. So it's not necessary to have such a definition in the Principal Act.
Not at this
I park that with you.
Yeah,
park it with you. Okay, good. Then can we now move on to clause 12 then? Deals with section 28.
Yeah, okay, Chair. There's an first of all, we support the principle that the municipal managers or municipalities can now also make use of section 24(8). And that is, that is, we support that. And I know there were some concerns about that, but we just simply want to say that we support that. Then also the amendments is to also refer to people that is in control of land. That may also be directed in terms of section 28. We also support that because it means that people that have land must be responsible for what happens on that land. So we also support that.
Okay. Can I just quickly ask, in terms of subsection F on the bill, page 13, line 39? Quickly ask, one of the comments was, I think it was also from the CER, said that people should be held jointly and severally liable. But I see there that the wording says from any or all of the following persons. So it for me comes down to the same as the old term used in partnerships, that partners will be held jointly and severally liable. From any or all, are you happy that it does mean jointly and severally, and that we therefore don't need to describe that? I don't know if Advocate Leroux would like to comment. It's clause 12F, right at the very end, just before D. Before, after such measures are taken and all costs incurred as a result of acting under subsection 7 from any or all of the following persons.
Chair, I'm looking at that, and it doesn't appear to me as though there's any reason for concern. So these costs will be recovered, and I suppose that process will be dealt with in the judicial process. And then a determination will be made whether a single person is liable or more than one person is liable, and how to apportion those damages or those costs.
But it allows, therefore, for the courts to hold any one person also responsible.
Yes. We agree
can we then?
Chair.
Thank you. Can we then step off clause 12? Clause 13, everybody seemed to be happy with that one. Same with 14. Then the next clause which warrants possible discussion is clause 15, where you're proposing that the designation must be in writing. Designate in writing as an environmental, mineral and petroleum inspector. Where does the in writing must be included?
Chair, that was again a comment from another department. I suppose it is just good governance that you put it in writing. So I mean, I don't have a problem with that, and it makes sense. I mean, yeah.
I think the right place to insert that word writing would then be in paragraph C. The addition of the following subsection, a designation in terms of subsection so may only be made by agreement between the minister responsible for mineral resources and the relevant organ of state. That the reference to the designation in writing must be referred to there. I wonder if Advocate Leroux would be able to just check that and help us so that next week we find the right wording and the right place for that.
Okay.
15 dealt with, 6 is fine. 17, there was just a request which sounded quite valid, that once a decision is taken that the minister must inform the complainant of the minister's, I don't know, decision or actions. But if you bring anything under the attention of the minister, apart from it being a good practice, I think it would be wonderful if we could say, but you know, your complainant must receive some feedback on that decision. Won't you just consider again the viability of including something to that effect under sections? I think it was under section 17.
Okay, Chair. In other words, that there's feedback to the
complainant.
Complainant.
The person who brought it under the minister's attention. Yes.
Yeah.
Please,
Chair, I mean, yeah, I
have
don't
a look
have
into that.
Yeah, I don't have any concern with that. I mean, I suppose it's good governance that you give feedback. The issue that we raised there is rather in terms of clause 17F, or that the section 31D8. We are happy with the provisions or the amendments that was made, and it stems from a court case that Ayub can give more detail to, but that where there is cooperative governance in terms of that all the competent authorities work together, and that if that fails, that that the minister must act. It's not again after concurrence or in concurrence with the minister responsible for mineral resources, because in clause 4 to 6 there has been concurrence all along. But if all of that fail, then in clause 8 you don't have to again go and in concurrence take action. Then concurrence have failed. Then the Minister of Environmental Affairs is bound to act, because then, so that's why we made the amendments. And in spite of subsection 4, then the Minister must act, and not in concurrence, because concurrence in terms of all the other subsections have already failed. Now you need to take action. So that's all we're proposing there.
Agreed. But will you please provide us with a suitable wording?
The wording, we did provide a redrafting of section 31D8. We did provide that, and yeah, it's there in our comments.
It's 7, paragraph 17. So the 8 is a completely new paragraph that you want in there.
No, it's not new, but we're redrafting it. We're taking out may in concurrence with the minister responsible for mineral resources. We're taking that out because from subsection 4 to 7 was already concurrence and consultation. Now, if all of that fails, then in subsection 8, you don't go and consult again. Then you take action. So we believe that you don't need, you delete the reference to concurrence, and then you must take action.
Thank you. I see the wording there. Thank you very much. That is the way we want it. It was just on the screen at the time. Thank you very much for that. Good. That brings us to section 18, happiness. Section 19, section 20. I think the next issue is then, yes, under section 20, 31G2 should also include references to or a municipal manager or a municipality. Good. Mineral and petroleum resource inspector. Environmental. Okay, so it's an environmental mineral and petroleum inspector. Can I just ask, where would you like that to be included? Where in the sentence? 31G.
Chair, I'll just have to check what makes sense.
Good. So hopefully at our next meeting we would be able to have that page there also marked with track changes as we have the bill in front of us. Okay. Then 21, section 21, which refers to 31H, and you referred to 4 and 5 under 31H. You are?
So I'm just trying to catch up again.
Okay, so it seems to me the consistency to refer all the right through to environmental, mineral, and petroleum inspectors.
Yes. So I'm with you now. Yes, Chair. Absolutely. Yeah.
So it's about consistency there. Thank you. Then also, can we go on to section 22, which deals with 31I? Or am I too quick now? It's fine. So 22 you're happy with, 23 you're happy with. Section 24, which deals with paragraph K is fine, but it's when we come to section 25, 31L, and there you also use the term minister responsible for, which is the wording which I favor as well.
Yeah, Chair.
Okay. Again, if we could get, and I don't know which official is going to assist us in this regard, because we don't seem to have the principal legislation in a Microsoft Word format, but if we could eventually pass it on to our representative in the NCOP, where we can show the original wording and then just with track changes, the changes that we propose from the Western Cape. Again, as I've said before, I think it will just result in end up in a better result at the NCOP. So I'm going to leave that with our procedural officer to just assist us and indicate who will be helping us in that regard. Good. Then the next one is there, clause 26. And the question is posed, clarity is required on the relationship between an objection in section 31M and an appeal in section 43. It is proposed that clarity is provided. Now, as I've said to you, something like that doesn't quite help us or the people reading what emerged from this committee. Can you give us the clarity, or can you go back and seek to provide some clarity or a wording that will provide that clarity?
Chair, it's difficult because we wanted to understand the clarity before we, so we actually requested the clarity, so because it wasn't clear in how it was stated.
Okay, so even if you do get now feedback from the National Department, please engage with them. And if it's still not clear, because if it's not clear to you, it might not be clear to people reading the legislation eventually, and it not be clear even in a, we don't want to go to court to get clarity, I presume. So I'm parking that you, I'm writing here, park clarity by next meeting. Good.
Chair, I can just come in there on that. And the objection is in terms of a compliance notice, and an appeal is in terms of a decision. So there's a difference. There is a difference between the two, and the nature of the two is dealt with separately. So objections are dealt with in terms of compliance exercises, and appeals are dealt with in terms of prospective decisions that decisions that are issued. So there is a difference between the two, but we'll expand on that.
Please do. And the same with 31N, which is not referred to in the bill. It seems to me then
on that one,
it needs a new clause.
No, like you have it in front of you there, 31L4 in the second row, and what we're saying there in 31N, it's not in the amendment bill in the D version, but these are consequent amendments that have to be pulled through in the main act. So if you look at 31, for example, it's a compliance notice that can be issued by the minister. Now, what they didn't do is that they didn't include the minister responsible for mineral resources or the minister responsible for water or municipal council. So they did, they included that wording in the issuing the upfront or the way they propose it, but they didn't pull it through into the other sections of the bill, of the act, not the bill, of the act. So all that we're saying there is if you're making a primary amendment, you've got to make sure that that those powers are now given to the other authorities that you've also given the original power to. So those are the proposals that we're making there.
Yes, we agree with that. The only problem is that the bill doesn't refer to sections 31N.
Yeah, the bill does,
but the
act does. It's included in the act.
Changed in the act.
Yes, it must be
Mr.
changed.
Mohammed?
That's what we're saying. So they must go back
The
to
way
the act, change that in the act, in the act the way it exists at the moment.
Mr. Mohammed, my understanding is the way you adjust the act is through this bill.
Yes, but they didn't do that, which is why we're reminding them.
Yes, and that is why I'm saying we want a clause 26A in the bill.
Yeah.
And change the principle. Am I
No, we understand. It's just we've made these comments to national, so we expect in the version that they issue the post D version, these changes would have been brought about.
Okay, but seems to be. I'm just saying here, section 26 is, and this is in my own language. 26A is needed to change 31 in for November or Nelly. Yeah. Okay.
Chair, that's where we refer. Chair, that's what we refer to. You have to make all the consequential changes. If you change a primary clause, then there's certain consequential changes throughout other clauses, other provisions in the Act that must follow, and they missed these consequential changes.
Please excuse my cynicism, but unless we do it, I'm not sure if it will be done on the other side. So I propose that we must point it out, and that's why I've said I think we need to insert extra sections in the bill to pull it through to the Principal Act. Okay. This brings us then to clause 27. And I see the CRR, it seems to me CR said that environmental management and petroleum inspector. Again, I think it's that is in section 31.0. Good, I think it's listed there, agree to, thank you. The 28, 29, and to section 30. Again, there's been a question about clause 30, paragraph 34E, which says that a live specimen that's been seized in part of this may be deposited with a suitable institution, replacing the word must. Now, my understanding is that sometimes, a live specimen that is being seized may be in such a condition that, you're unable to find a suitable institution, rescue center or facility which is able and willing to house and properly care for a specimen. And that we then go with the word may, or if I missed some important parts. You say CD, you also, please help me here. You say it's not clear why the must was changed to may when it comes to the placement of live specimen in a suitable institution. And as I've just said, we've recently had a case where Cape Nature put down an animal to the which the public was very, very upset about. But you don't see, you say it must remain must. Please say if the animal is suffering, if the animal is not in a condition to be rehabilitated or treated. Who's going to comment on that one?
Chair, it's not a question that we fixed on that it must remain a must. It was not clear what was the argument around it. But if, for instance, as you explained it, this is not a train smash, if I can put it bluntly. If it remains in May, it's not the end of the world. It's fine.
I think the chair, if the option, if you read the principal act, the act as it currently stands, because you must read it in context. It says pending the institution of criminal proceedings, a live specimen that has been seized in terms of this part must be deposited in a suitable institution, rescue center, or facility which is able or willing to house and properly care for it. So by making it a may, we're just bringing in some discretion that it doesn't have to go to a suitable institution. It can be housed or it can be held somewhere as long as it's safe, and it can be, because this is specimens that's going to be used in criminal proceedings. So like Paul said, we're not fixed on it being a must, and maybe the may is a better one, because then you don't have to. Part of the problem is if they seize things over a weekend, for example, there's no institutions that you are able to approach to house the specimen. So that brings in the level of discretion, and you don't have to find a suitable institution. So I mean, yeah, like Paul said, I don't think we should be hard on this one. It can be a may, we can leave it as a may.
Can I ask that you go back and just consider something in between, where one would not make it easy for people just to destroy specimens, but that we say, you must first explore, you must apply your mind, you must see whether you would be able to find a suitable institution, and once, so that you must be able to prove afterwards that, after 5 phone calls or whatever, you are unable to find such an institution, a rescue center. That the first option would be try and keep the specimen alive, but if you're unable to find such an institution, that then you may you may therefore then get rid of the specimen. So can we ask that you just see if there can't be something between the must and the may? On the same page, we want to achieve the same. It's just that I think we're currently, words are probably failing me. Definitely they are. Okay, good. And then okay, so you say it should be reconsidered, but perhaps if I can ask that you then come back with heading which might bring us all on the same page as far as that is concerned. Okay, good. Honourable members, this I wonder if we would be able to deal with the next 3 clauses still, and then I'm going to call it a day. Clause 31, I think we all. You have a number of clauses which you also want to be amended, which is not currently included between 30 and 31. Okay, shall we again see what the department comes back with on that one? It's very difficult for us now. National department will come back. Yeah. Okay. So that brings us then to clause 31, which deals with section 34D. Ms. Niekerk, if you could scroll the next provision that you have there. Can you scroll further? It seems to me clause 31 we're all on the same page with, which brings us to 32, which is probably the last one that we will have time to discuss today. It deals with section 42B, and there it says subject to any, and I'm referring to subsection 2, may be withdrawn by the minister responsible for mineral resources, subject to any right may have accrued to any person. Mr. Hardcastle, can I just ask if your deletion of that, if people have already accrued any rights, why would you like that part of the paragraph to be scrapped? Are you still with us?
Sorry, Chair. I muted myself again. It's again, for me, very difficult to comment on that one because it wasn't forthcoming from our department. Other to say that it's my understanding from the comment that was made was that it's unnecessary actually to make those and consistent with other provisions in the Act that you don't need to consider those that additional wording.
Okay, good.
Okay. It's not clear why the wording has been provided, and then also you can argue that there's other sections in the Act that also that wording must be provided. So yeah, Chair, the comment was that why can't we just delete those wording? What will it do if the question is rather what does it take away if that wording is deleted? According to me, it doesn't take away anything. You have to consider in decision making anyway those rights.
Okay, good. Thank you. Honourable members, officials, I would like to say this meeting was scheduled from 9 o'clock until 12 o'clock. I know we're in a disadvantaged position again with the National Department not serving us with their comments. But I do believe that we're all much more au fait again with this. I think we've had a refresher course on the bill, and I do hope that quite a number of issues we've been able to clarify amongst ourselves. So I want to thank you very much to every one of you for that. And with that, officials, you are free to leave this meeting. We just have to approve of the minutes of our previous meeting, and then also there's just something which I need to share with you as a committee. But I will say, especially to Mr. Hardcastle, Mr. Mohammed, and Advocate Leroux, thank you very much for your inputs. And again, I think we've seen the value of that matrix which Ms. Nikak drew up. And I want to say thank you very much to her as well for her hard work in that regard. It really was a great help to keep us all, by figure of speech, on the same page. So thank you very much. Members, if you could just remain for a quick closing of the meeting in terms of the consideration of our previous minutes. Thank you very much.
Thank you, Chair. Goodbye.
Okay. Thank you. Thank you so much, Mr. Members. Thank you, and go well, and thank you. I believe we leave you with some homework, and I appreciate in advance your attention to that. Thank you. Honourable members, just two things. I wonder if Mr. Nikak, if you would be able to beam up the minutes of the previous meeting. Can I just make sure, are we still quorate?
Yes, we are, Chair, and the minutes should be on your screen now. Excuse me.
Yet on mine, turn on incoming video. I don't know if that will help. It's not on my screen, Ms. Nikak. Honourable members, do you see it?
Yes, I can see it, Chair.
Now, why is my... I just hear a lot of background noise. I don't see it on my screen, Ms. Nikak.
I don't know, Chairperson, but it should definitely be up. I've shared it. The minutes of the 12th of August.
Move down so that we can see.
Oh, there it is.
Yeah.
Thank you. It just took a while to appear here on my screen. Page 1.
Okay.
Page 2, the long list of officials that attended. So from the National Department. I think this is one of the advantages of Microsoft Teams. But can we go on to the next page, please? Or is mine so slow? I wonder why I'm still stuck here with the National Department officials on my screen.
I'm on the resolution action page now, Chairperson. Point number 3.
Very interesting. It's not coming up. It's not on my page, so I'll put page 3 to you, Honourable Member.
Sharon, move a little bit and then it will get quicker to Chairperson. Just move there.
There it is.
There you go.
There it is.
Okay.
Thank you. Thank you. Good advice. You must move.
I must just move quicker.
Yes, please. Good. Thank you. And that is the last page, Honourable Members. A proposal that we adopt this.
Yeah, I move that we adopt this, Chairperson.
Thank you. Honourable Maseko, I think you and I were the only ones in that meeting. We can't expect of Honourable America to second that. So it's adopted. Thank you, Honourable Members. That is then dealt with. And then, members, what I just wanted to share with you is that I received from the chairperson of CASIDRA that they had a disciplinary hearing against their former CEO, Mr. Seymour, Ashley Seymour, and that the hearing was concluded and that Mr. Seymour unfortunately was dismissed on the 17th of July, and CASIDRA will now start with the recruitment process to fill the vacancy of their CEO. That also explains why the Chief Financial Officer has been representing CASIDRA at our last meetings here. Obviously, this is always sad when things like this happens, but this is not for us to deal with. I'm satisfied that the board would not have taken this decision unless they've been convinced that this is in the best interests of CASIDRA. And honourable members, I think the less said about this for now is best. And I want to thank you all for your participation this morning in this meeting. It is tough dealing with such complicated legislation, and a particular word of thanks again to Ms. Niekerk. And Ms. Niekerk, we will see each other, am I correct, next Tuesday again in the morning time slot?
No, you are correct. We'll see each other next week, Tuesday, but that's the oversight visit to the Overstrand area, Chair.
Oh, yes.
Yeah.
Our next meeting will then only be...
Our next meeting, yeah.
Honourable members, yes. So we will be travelling to Hermanus, to the Milkwood Forest, the Abalone Farmers Association. We will be staying over then for those that wish to do so in Hermanus. And then on the Wednesday, we will be visiting Kogelberg Nature Reserve of Cape Nature, as well as the possibility of a game farm, safari farm. It has been in the news because they applied for the relocation of certain wild animals, and that still needs to be confirmed. Am I correct, Ms. Niekerk? The
That's
visit
correct,
to the safari farm.
Yes, correct.
Good. Thank you very much, honourable members. And with that, I wish you all a very good day. The meeting is adjourned.
Thank you, Chairperson.
Thank you, Chair.
Shireen.
Thank you, Honourable Maseko, for
You're
your
welcome,
suggestion that our procedural officer must move. It helped. and now we're all going to move out. Thank you.
Bye-bye.
Bye. Bye.